Welcome to the Lawyer Society Legal Podcast. In today's episode, we'll be talking about quash petitions. When can we file a quash petition and whether there is a possibility of filing a second quash petition in case the first one is dismissed. Basically, a quash petition is one that is filed under Section 482 of the CRPC or Article 226 of the Constitution. A quash petition can be filed challenging or praying to quash a first information report, that is an FIR, or a charge sheet. It is basically filed to end any criminal proceeding that has been filed against you or your client. Ideally speaking, a quash petition can be filed at the inception itself, that is when an FIR is being filed or a complaint before the magistrate is initiated. Only when the complaint or the FIR itself is manifestly absurd, that is, if you look at it, there is no offence that is disclosed, no prima facie case is made out, then the court will entertain a quash petition. It will allow the quash petition, quash the FIR or complaint made before the magistrate. But in case the FIR or the complaint discloses prima facie ingredients, you should know that prima facie doesn't require delving into the evidence, delving into much further details. So on the face of it, if the ingredients are made out, the court will not entertain any quash petitions at that time. In case it is being dismissed, what will be the right time or when will be the right time to go for a second quash petition? As in the case of filing a second bail petition, which we have already discussed in one of our previous episodes, which you are always free to go and listen to. There has to be a changed circumstance in order to file a second quash petition. A changed circumstance can vary from case to case. And when you are putting forth a prayer saying the circumstances have changed and I have found a new fact or there has been a development in the case, this entitles me to file the second quash petition. You must ensure that the same prayer was not available to you at the time of filing the first petition. Now, the court will see if the second quash petition or the prayer contained in the second quash petition was within your knowledge when you filed the first quash petition, or if it was not within your knowledge, the court will look at whether with due diligence you could have discovered that fact when you filed the first quash petition. If you could have discovered the fact, then the court will say that it was your negligence that you didn't go for the same prayer in the first petition itself. In case it was not within your knowledge, the court will entertain it. And obviously if it is a new development, then the court will entertain the second quash petition. Entertaining is not equal to allowing it. They will admit the quash petition and they will agree to listen to your prayer, but granting it is a totally different question. So when will the court grant a favorable order when you file a second quash petition? The first one will always be limitation. Suppose the limitation for a particular offence is 3 years. Some courts are of the opinion that limitation applies for the period from when the offence is committed or when it comes to the knowledge of the informant and when the charge sheet is filed. So these are the two dates, starting and ending time, that is being considered by some of the courts. In such a scenario, if the limitation period is 3 years and the investigation has been going on for 5 years since the informant had knowledge of the offence, so you can say that there has been a delay of 2 years in filing the charge sheet before a magistrate. But there is an exception to this, that is, the magistrate can always condone a delay that has been made in the investigation. So the High Court can look at the nature of the offence, the nature of the delay and the reasons for the delay that is being quoted by the investigating officer, and the High Court is always free to decide, okay, this is a fair reason, but I'm giving you 2 more months to complete the investigation and file a charge sheet before the magistrate. Let the magistrate exercise his discretion under Section 473 of the CRPC. Let him decide on the question of whether to condone the delay or not. So the High Court has the power to direct the investigation to be completed within a certain period and filing of charge sheet. So this happens regularly in several courts. Now the second ground is delay in trial. If you see in a case of Superintendent and Remembrancer of Legal Affairs, West Bengal versus Mohan Singh, the Honorable Supreme Court observed that in case the first quash petition was dismissed earlier and the trial has been dragged on for a long time, then if there is no progress, a second quash petition can be maintained. But there is an exception even to this, which is when the accused person himself is contributing to the delay in the conclusion of the trial. Then you can't say that it is a changed circumstance, because the accused cannot take benefit of something that has happened because of him. This was said by the Andhra Pradesh High Court in the case of R.G. Chandramohan versus Andhra Pradesh. I will leave the citations of these cases in the description box below, so please do go through these judgments in order to get more clarity on the same. So what are the other obvious changed circumstances? Suppose you filed a quash petition when the FIR was yet to be converted into a charge sheet, but now the charge sheet has been filed. Obviously, when the charge sheet has been filed, you have the luxury of putting before the court the different statements, the evidence collected, so on and so forth. Obviously, High Court cannot consider the evidence that has been collected, but they will have more material to consider for the purpose of looking at whether there is a valid case for trial. Now, when the charge sheet is filed, you can call it a changed circumstance. For this, you can look at the case of Magistrate of First Class versus Bhajan Lal, again from the Andhra Pradesh High Court. Now, you can also look at the scenario where High Court has given a time limit for the filing of charge sheet. Say there has already been some delay in filing of charge sheet, and the High Court has directed that the police must be filing the charge sheet before so and so time, say a reasonable time of 3 months, and the police hasn't filed the charge sheet at the end of the 3-month period or even after that. Then you can prefer a quash petition saying, okay, despite the High Court making a direction, the police hasn't concluded the investigation, they haven't filed the charge sheet. So all this is infringing the rights of the accused person. As I already said, even in such circumstances, the complainant, that is the informant, can go for an appeal. He can challenge the quashing, stating the court cannot fix any timeline for the police to investigate, and the police can also go for an appeal stating, okay, we had valid reasons for the delay and we couldn't collect so and so evidence, that's why we weren't able to file the charge sheet. It depends on each case, and the facts and circumstances of each case are different. So you can always think of various, reasons or grounds which you can call as changed circumstances. It's the same as when you are filing a second bail petition. You can think of various things that has happened from the point when the first quash petition was dismissed and the current time, and you can think of the developments that have occurred between the said time interval, and from that you can conjure a ground stating the same is a changed circumstance, so your client deserves to be heard on that basis. I hope this episode was useful to you, and a quash petition is a very basic thing on the criminal side, and it is very important to understand how this works. Please do share it with your legal friends and legal community. Listen to our other episodes on Spotify and YouTube for more legal information. If you're interested to read on these topics, you can subscribe to our digital law magazine. I will leave the subscription details in the description box below. Let me know your thoughts. Do comment, do share. Thank you.